Hi, and welcome to the Estate Planning for the Service Member webinar. I'm Lieutenant Colonel David Delaney, Attorney and Advisor for the Department of Defense and the Office of Legal Policy. And joining me here today is Ms. Mary Benziger, the Pentagon Senior Legal Assistance Attorney, and I'm so thankful that she is here because I can think of no one else more qualified and experienced in estate planning for service members than her. So I want to thank her first and most of all for joining us here today. Now, before we begin, we are both lawyers, and so we have to do the legal thing. We have to provide a disclaimer. And yes, this is not something that most people will be worried about whenever they join us for a webinar, but we do this because it is important for you to know that this brief is informational only and should not be construed as legal advice. So if you find yourself wanting to know more about estate planning or have questions regarding your own estate planning needs, good. That's the purpose of this webinar. That is one of our objectives, and we want you to come away with those questions because we're going to provide you with information about how you can find your services, free legal services, to help you with your estate plan. So let's talk about our briefing objectives today. As I alluded to, this webinar is designed to familiarize you with the fundamentals of estate planning, common estate planning issues, common tools and techniques for end-of-life and healthcare concerns, and also to provide you the legal resources available to service members to help you with their estate planning needs. So let's talk about estate planning. I've used this phrase several times already throughout this briefing. So what does that term mean, estate planning? Estate planning is a continuous process for the arranging for the use, conservation, and transfer of one's property or wealth during their life and upon death. That is what estate planning is. But what estate planning does is much more meaningful. Estate planning helps bring peace of mind and increase readiness for the service member. But before you reach that peace of mind that comes from knowing that you are prepared for life's eventualities, you must start this continuous process of estate planning. So first you got to determine what you want to have happen. What are your goals? And just like with any other planning processes, the first step in estate planning is establishing your goals. Some general goals of estate planning are taking care of your family, taking care of your property, and taking care of yourself. So Mary, most clients are most concerned about taking care of the most vulnerable of their family members upon their death, their children. And I know that you're going to talk about the legal products used in estate planning that can ease that concern, particularly in the blended family situation. But also we're going to talk about that other goal, which is taking care of specific pieces of property to go to specific family members or used for a particular purpose. That's called bequest of property. For instance, ensuring that your grandmother's wedding ring is passed down to your daughter. Also, it could be taking the property and putting in a legal entity known as a trust to take care of your family members or even yourself if you're not able to. And finally, clients also want to know how they can act to take care of themselves now so that if they become incapacitated in the future, they can ease the burden on their family members or those who would be needed to take care of them. And so it's important that we talk about what the goals of estate planning are, but those are the general ones. So as we go through this briefing, I want you to think, what are my goals? What do I need to accomplish with my estate plan so that I can take care of my family, take care of my things, and also take care of myself? So let's talk about what is actually in your estate. Your estate is essentially everything that you own. It's your home, your car, your bank accounts, investments, retirement benefits such as IRAs or even your TSP account. It's your collectibles, personal belongings, even benefits that accrue to your beneficiaries upon your death, like life insurance and survivor benefits. And for service members, the biggest portion of their estate is typically the service member group life insurance policy because that maximum benefit for SGLI, which is the default amount for most service members, is $400,000. That is going to be the majority of their estate, but your estate encompasses everything that you own. But from your gross estate, that entire amount of everything that you own, we can further separate the estate into two different categories, probate and non-probate estate. Probate estate, that is what comes from your entire estate that passes to someone else other than yourself through your will or by operation of state probate laws. Non-probate estate, everything that passes to someone else without going through that probate process, is what's considered as your non-probate estate. This distinction, probate and non-probate, is important because much of our discussion today regarding estate planning will be to avoid the costly, time-consuming, and generally unpleasant process of transferring the probate estate state's probate system. Remember, the general goals of estate planning are to take care of your family and property upon your death, and can reduce the value of your estate, which can be detrimental to your family's needs. So let's talk about also what's part of your estate plan, the components of it. So now that we've discussed that, let's look at some of the typical things that you will find whenever you come out of this estate planning process, such as legal documents and other financial documents. Listed on this slide are many of the documents we'll be discussing, such as trusts, advanced medical directives, powers of attorney, and also letters of instructions. But as an estate plan, it consists of these legal documents, of course, but your estate plan is also a call for action. Estate planning may require you to retitle your assets to obtain a certain estate plan objective, or filling out forms with your financial institutions. An estate plan is more than just the documents you put in a safe. It is the actions you take now to take care of your family, property, and yourself later. So I'm going to bring Mary in now to share with us some of the estate planning techniques she advises her clients to use to obtain their estate planning goals.
Thank you, David. Let's take a look at some of what these techniques are. There's kind of the ever-popular do nothing, which we'll talk about in length. Not a good idea. Lots of ramifications for that. We'll talk a lot about how joint ownership and beneficiary transfers work in your estate plan, and we'll also talk about wills and trusts at length also. So let's talk about what happens if you do nothing. If you do absolutely nothing in your world, you don't pay any attention to your accounts, you don't pay any attention to your relatives, you don't pay any attention to anything, what happens when you die? You're almost guaranteed that your assets are going to have to pass through the probate court proceeding, and we'll talk more about how probate works in a second. But if you take no actions, your assets will likely be distributed in what states call an intestacy statute. Intestacy means you've died without a will, and so your belongings have to go somewhere. Your assets have to go somewhere, and where they go will be determined by this state structured game plan. So every state has one. For example, it can be if you die without a will, let's say in Virginia, and you're single, your assets go to your parents first. If you don't have parents, then it goes to your siblings. So that may not be what you want, but that's how that's going to work. If you become incapacitated during your lifetime and you haven't done any planning, you're pretty much going to require the invocation of some court-controlled events. A court-appointed guardian. That could be a friend or a family member. It could also be a complete stranger. So you have to think about how that would work for you, someone who doesn't even know you, controlling your assets and making medical decisions for you if you can't do it yourself. Also, if you have children and you've not done any planning, the court is going to decide for themselves who's going to take care of your children. That may not be who you want. And you could be setting your family up for a court battle over who takes care of your children. So as you can see, there's some pretty bad consequences to doing absolutely nothing. And I've had plenty of people say, I'll just let everybody sort it out when I die. That's a bad plan. You're setting your family up for failure and fighting, and it's just irresponsible not to plan and to be able to get what you want out of this. I mean, this is your stuff, your children, your life. If you plan, you more likely guarantee that you get exactly what you want. So let's talk about wills next, and how and what wills actually are and how they're structured. And if you actually read a will, you would see pretty much this layout on them. You would see some bequests, gifts and devises of your real estate, your personal property. Specific bequests maybe, as David said, your grandmother's wedding ring to your daughter. And then a gift of the residuary estate, the residue and remainder of my estate, the rest of your stuff, not taken care of by those first three bullet points. You may also want to establish certain kinds of trusts for children, special needs kids, pour-over wills if you have certain kinds of estate planning. You may also need tax planning trusts. David will talk later about some of the tax planning issues that are involved in estates. You may also be appointing fiduciaries. Fiduciaries, everybody remembers those old 1930s movies where every dog was named Fido. That's from the Latin to be faithful. I am faithful is what it literally means. These are your Fidos. These are your trustworthy individuals who are going to act in your place to do something for you in your stead. So we're talking about trustees, executors, guardians. Typically in a will, I put in someone's preference on funeral arrangements. I don't have any objection to doing that. But you have to understand that by the time they find your will after you're dead, they may have done something else with you if you haven't otherwise expressed your preference on funeral arrangements. So I always counsel people to please tell others what you want. I remember when my mother was aging, about every 10th phone call with my mother, she told me exactly how she wanted to be buried. I got tired of hearing it, but I knew what she wanted when she died, and that's very important. So keep that in mind, please. Let's go ahead and talk about probate and how probate works. Probate is a legal way to change title. The law doesn't want your assets to be owned by no one at your death. Someone has to get your stuff, mostly so we can tax them. But it's a legal way to change title, and it works like this. If I die, my brother is my executor. He takes my will down to the courthouse. He opens up a probate proceeding. And he does that by presenting the original will to the clerk of the court. And the clerk of the court is going to look at the will and prove the will. They're going to make sure all the pages are there, that it's properly signed and properly witnessed. And once they've proved the will, hence the word probate, once they've proved the will, they're going to open up a probate proceeding, which in large part is just an administrative process. As soon as the will is validated and my brother qualifies as the executor, that's going to trigger a whole bunch of duties in him. He's going to be responsible for notifying my potential heirs, notifying my creditors, finding all my assets, and reporting those to the court in the form of inventories and accountings. And this could take a year. This could take 2 years. It's a very long and tedious process. Once the court is satisfied that my taxes have been paid, that my debts are paid, and any claims are settled, they will authorize my brother as my executor to distribute my assets in accordance with my will. It could be pretty far down the line, okay? So that's how probate works. So let's talk next about which assets have to go through that court proceeding and which do not, because there's sort of option A and option B. Option A, letting things go through the court process to be distributed to new owners in accordance with your will, or intestacy statutes if you had no will. Or there's ways for your assets to go directly to a new owner at your death by operation of law, effectively, or contract. So one of the things I do when I have people come into my office and they want a will written is to make them give me a list of their assets and how they're owned. Because it's all about ownership in the end. So things that are going to go through probate. When you're looking at your assets written down on a piece of paper, if you list them all out and you look at them one by one, how do you decide what's going to have to go through that terrible court process and what's not? I tell my clients it's a simple test. I call it the orphan property test. So let's say I own a home in my own name and I die. Once I'm dead, my home no longer has a human owner. It's an orphan. Orphans go through probate. And you can do that with every single asset you have. Bank accounts, checking account, solely titled in my name. I die, it's an orphan. It's going through probate. Okay. So anything that's solely titled is likely to be a probate asset, absent other actions you can take to change that. Be also aware of things like they're titled just joint, typically a checking account. Your 80-year-old mom wants you to write checks for her. She goes into the bank may put you on there as a joint account holder. That does not convey much ownership interest to you at all. And certainly at your mom's death, no ownership interest in that account if that money derived from your mother's assets, like for Social Security check, for example. So don't assume that just because it says joint that is not going to be a probate asset, that the money in there is not going to be orphaned when your mom dies. Be careful also, or be mindful also, of something called tenants in common. Tenants in common is a way typically to hold property. Often you see with real estate held by people who aren't married. So if my brother and I buy a condominium together, the title is likely to be tenants in common. That means we each have a yet to be divided or yet to be determined divisible share. But let's, for the sake of argument, say we have a 50-50 share in this condominium. If I die, my share of that condominium is an orphan and is willable. Okay, so you have to be mindful that tenants in common means there's a willable share in here, and it's going through probate. Okay, how does non-probate assets work? What ones can you identify as non-probate assets? Any asset or account that's titled joint with right of survivorship. Those words, right of survivorship, are important. They mean the last man standing alive wins. So if David and I have a checking account together and it's joint with right of survivorship, if I die, the money in there is his. If he dies, the money in there is mine. The survivorship component controls who owns it at the death of the other joint tenant. Okay? There's something called tenants by the entireties. I think it's about 26 states have these. This is typically for married couples. You also see it mostly with real estate. Some states will let you do bank accounts and vehicles, but most commonly you'll see it with real estate. And you'll see a phrase that says tenants by the entireties with common law right of survivorship. Again, that has a survivorship component. Last man standing wins. Spouse A dies, spouse B gets, spouse B dies, spouse A gets. That's just the way those work. And that's all outside of probate because you left a surviving owner at your death by virtue of the title. All right. Now, for some other things you can do, for example, my checking account, my name only. I would like that to stay in my name only, but I'd like my brother to have it at my death. How do I do that? Many states, almost all states, have something called a pay on death. These are statutory, or a transfer on death, a POD or a TOD designation you can do. You can walk into the bank and you can say, I want to make my brother my death beneficiary. They're going to give you a little form, you fill it out. And what that form means is at my death, they will pay my brother the money in my checking account. It does not confer ownership interest in him. So during my lifetime, he can't walk into the bank and try to clean out my checking account. They're not going to let him. He is not an account owner. But at my death, they're going to pay him, and they're going to pay him outside of probate because he's my surviving owner by virtue of a contract between me and the bank. There's also beneficiary designations you can put on some assets. We'll talk about some of those a little bit more maybe. Life insurance, for example, has a beneficiary designation. So when you die, it's not an orphan because it's going to pay your spouse, for example, or your children, for example. So that doesn't need to go through probate. You've left a surviving owner with a beneficiary designation, a contract between you and your life insurance company. Inter vivos trust property, living trust, we'll talk a lot more about that in a second, but just I want you to know that that's in sort of the non-probate column if you do it right, and we'll talk about how that is done properly in a minute. There was a way of going on a few years ago to put transfer on deaths on vehicles. I've given you a Virginia example, and I'll give you a list of states in a second that have these transfer on death statutory deeds. Transfer on death for motor vehicles is great. It varies by state a great deal, though. This is just the Virginia example. This is by no means the example in every state. Virginia says it must be solely titled and have no liens, and the beneficiary has to be a real live person. If you die, your beneficiary has to claim it within 120 days of your death. So if I own a car in my own name and I die, it's an orphan. I don't want that. In Virginia, I can put a beneficiary on there so that at my death it belongs automatically to someone else. They just have to go claim it. This is a great estate planning tool. And it does vary by state. I think my recollection is in Maryland, the car can have a lien and you can still do it. Now, in states where they let you have a lien on the car, you know, a note on the car still owing to the bank and let you do it, that any of these transfer on death devices, beneficiary transactions, do not get rid of the lien. The lien still runs with the property, so your heir is going to have to sell the vehicle or refinance the lien or something like that. But it does keep it out of probate, which is kind of handy. They're also doing, some of these states are also doing transfer on death for real property. Virginia is one of those, and like I said, I'll give you a list in a second of others. I'm not going to hammer through all the details on Virginia, but suffice it to say that you can put a transfer on death deed, which is it's a statutory deed. It's a form recorded in land records. I think it costs like $23 whole to record one of these in land records. So if I own a house in Virginia in my own name, I die, I don't want it to go through probate, I could put a transfer on death deed on here. Again, like all these other beneficiary designations, it does not change ownership during my lifetime. I have to be dead. Once I'm dead, my house belongs to my brother if I've named him on the transfer on death deed. But it's a cheap, easy, efficient way to make sure that my asset owned in my name only goes to someone else at my death without the need for probate. On the next slide, I've got a list of states that currently have a TOD statutes in some fashion, whether it's real estate only, cars and real property, or cars only. Good to know. If you have property in one of these states, by all means, contact an attorney out there and see if they can help you do the transfer on death deeds. They're a very inexpensive and efficient way to probate-proof an asset. Be mindful also that when you put these transfer on death designations on a piece of property, they're not necessarily permanent. You may change these anytime you want, which gives you great flexibility in planning. So if I put my brother on my checking account and a year later decide, oh, I don't really want him to have that, I'd like my sister to have that instead, I just go to the bank and I fill out another form. I don't have to change my will. I don't have to change title on my bank account. I just go change the form. So these are very flexible, very clean, easy ways to deal with property. These are governed by state and federal law. I will warn you that if you do these designations, it's a really good idea to follow up with the financial institution and make sure that they are have been properly filed and that they actually are in your records. I had a surprise when I got married. I went and looked at my official employment record, and designations that I had done for my spouse didn't make it to the file, much to my surprise. And that would have been a real problem because my previous beneficiary was my mother, who was in a nursing home. So it behooves you to do your homework on these and check and make sure that once they're done, that they're actually on file and done right, okay? But the kinds of things you can beneficiary designate are life insurance. You can put these on your IRAs, thrift savings plans, 401ks, any kind of government benefits, bank accounts, CDs, money markets, investment accounts, real estate, vehicles in some states. The only time a court is going to get involved and look behind these is if your beneficiary becomes incapacitated and is now in a guardianship kind of status maybe. If your beneficiary dies before you do, they're not around to get it. So you're going to have to be, again, the other thing is homework. Periodically make sure that these are still effective. If you make your beneficiary designation my estate, and you may want to do that for some tax planning issues, but if you're just doing that because you can't think of anything else to do, don't do it. My estate means probate. So all you're doing is sending that asset straight to probate. And a court might get involved if your beneficiary is a minor, and we'll talk more about money and kids in a few minutes, okay? Let's go briefly to inter vivos trusts, sometimes called living trusts. You probably hear some people on TV touting these, and occasionally you get a letter in the mail from someone who is trying to sell you one of these. Let's talk about how they work. For most people, you're talking about what's called a revocable living trust. This is a pretty thick document that you're going to get from a private attorney. They can be a little bit on the pricey side. With a revocable trust, you maintain control of the assets in the trust. So you can buy and sell assets and hold them in the name of the trust. Irrevocable trusts are usually tax planning, and they mean you give away very large sums of money to a trust. You cannot get that money back out but you can get income from it. Most folks don't have that happy problem, okay? So for most of us, you're going to be using a revocable living trust. How does it avoid probate? Okay, it works like this. Remember that house I own in my own name? If I die, it's an orphan. I don't want that. My house isn't in a state where I could take advantage of a transfer on death deed. Don't have one. For example, Maryland doesn't have a transfer on death deed. So I could put my brother's name on the title with me, joint with right of survivorship, but that could be subject to problems. What if he gets in financial trouble and creditors come after the house? What if he gets divorced and the house gets sucked up as part of that? What if he just turns out to be not such a nice guy and wants a piece of the house? That's going to be a problem. So I don't want to put him necessarily on my house, but I still want him to have it. So what I would do is have a living trust drafted. And this is how the living trust would work to avoid probate. I would sell my house with a recorded deed and land records from me, Mary Benzinger, to the Mary Benzinger Living Trust and record that deed and land records. So at my death, it's not an orphan because the trust owns it. Now we look at the trust. What does the trust say? The trust says, dear brother George, sell the house and keep the proceeds for yourself, or sell the house and distribute the proceeds in equal shares amongst my nieces and nephews. It will have a disposition section that sounds sort of will-like. Here's what to do with my property after I'm dead. But that's how it avoids probate. So any property that the trust owns does not go through probate because the trust owns it. It's not an orphan when I die. But as you see from this slide, trusts have got to be funded to work. You have to actually either retitle an asset like a bank account or a house in the name of the trust, or make the trust the beneficiary of that asset, so it will then avoid probate. There's also something called ancillary probate. The classic example is the soldier who's single and has bought a house in every duty station they've ever been in. They own 5 houses in 5 different states. Well, that's 5 probates, maybe 6. One for where you live, where you die, and the other probates called ancillary probates everywhere you have a house. That's a lot of probate, and that's going to be a whole lot of not fun for your executor. So that's how ancillary probate works. A lot of people prefer inter vivos trust, living trusts, because they're more private. Remember, anytime you open up a public probate in a courthouse, anyone can look at it. It is a public event. The other kind of nice feature of inter vivos trust is they can provide for some incapacity planning and incapacity maintenance and management of your assets. So that's kind of a handy thing. You still have to have a will called a pour-over will. It doesn't obviate the need for a will. A pour-over will is just what it sounds like. It says, oops, if I forgot anything, then I have a probate asset, pour that over, give that to the trust, okay? So let's shift gears a little bit, and let's talk about a trust planning for kids and minor kids. Here's the problem with leaving money to children, underage children. If you just name them, your life insurance, for example. I name my 5-year-old daughter Sally on my life insurance and I die. My life insurance company isn't going to pay Sally. She's only 5. So what they're going to do is they're going to hold the money until Sally turns 18 or until another adult qualifies as the guardian of her property. There are some, that's not necessarily a bad thing. The guardianship is of her assets is court controlled and court monitored. But there are, I think, some general shortfalls to guardianships. The first being that courts can be kind of cheap about the money, and they don't really want the guardian to spend it. And so they won't authorize distributions as generously as you might like. The guardian also has to go back to court a lot to ask for money, and that's kind of a hassle. The real risk, I think, is that for the typical guardianship, the child gets the money, which could be a lot of money, when they turn 18, and nobody cares what they're like. So you could have an 18-year-old getting, $2 or $3 million. That probably is not going to be a good thing. I mean, even if you have the most responsible 18-year-old in the world in your hands, there's still a whole lot of people out there who are predators, and they're going to try real hard to get it away. And they might succeed, because that's what happens in the real world, and your kid may not be set up to deal with that. So one of the things that I usually ask people to do, or suggest anyway they do, is something called a residuary trust. So in your will, you would have something that says, a typical example, everything to my spouse if my spouse survives me. If my spouse doesn't survive me, then in trust for my kids. So you need a will that says that. And what happens is, if both you and your spouse are deceased, this trust is going to appear. This is not a living trust. This is a testamentary trust. It's a trust that is in your last will and testament. It's also a contingent trust. It's contingent upon, in this case, both you and your spouse being dead. As long as one of you survives, this trust never pops into being. If both of you are gone, you have minor children, up pops this trust. Okay, so it's contingent and it's testamentary. So once you set that up in your will, your lawyer, your legal assistance attorney, or your private attorney will help you with beneficiary designations to designate your life insurance or your bank accounts or whatever you want to do in a typical distribution that says the primary beneficiary is my spouse, and if my spouse doesn't survive me, then to my trustee for the trust of my kids established under my last will and testament. That's kind of a typical single-family unit plan to take care of kids. Let's take a look at what happens when you've got a blended family. There's some unique issues if you have a blended family. If you or your spouse have children from a prior relationship, that's something that you need to think about, and how you're going to take care of those kids. If you leave everything to your current spouse, who's not the biological parent of your other kids, that person, albeit a nice person, has no obligation to take care of your children from your previous relationship. And even if they are well-meaning, the odds are high that over time they're going to lose contact with your kids, and your kids may wind up with nothing. And there's no malice in that. It's just the way the world works. But I've also seen some malice, and that's something you kind of want to avoid. Because for blended families, your kids from your previous relationship may very well get left out in the cold. All right. There's something called an elective share also. So if you're thinking about, well, I'll just disinherit my spouse and leave everything to my kids, you may not be able to do that in many states. Many states have a statute on the books that allows your spouse to elect a share of your estate, notwithstanding what's in your will. A lot of places call it elect against the will. So you're not necessarily able to foreclose your spouse from inheriting. Okay, so let's talk about what happens if in a remarriage situation like we've been talking about. So you've got Master Sergeant and Mrs. Smith with little Junior, and a Master Sergeant dies, and now you've got Mrs. Smith and Junior all by themselves. Mrs. Smith remarries, and all of a sudden she dies, and it leaves everything to her new spouse. Well, Junior's out of luck. He's just not in line to inherit. You've left everything to another adult, and he may or may not take care of your kid with it. He has no responsibility to do this. And so this requires some careful planning. This requires some hard conversations with your current spouse if you have children from a previous relationship. But it is your obligation to plan for your own children. It should not be someone else's obligation. Okay, so what are some solutions to the blended family problem of a spouse potentially electing against the will and your kids not getting anything? Well, here's one way to do it is by a contract between you and your new spouse. You can do prenuptial agreements. You can do postnuptial agreements. And in those agreements, you can agree to waive the elective share. So this is what a lot of people do when they get married in their later years. And, you know, spouse A has kids from their prior that are grown up, and spouse B has kids from their prior that are grown up, and they each have their own assets. And while they want to join forces and get married and be a household, they also want to protect those assets for the benefit of their own biological children. So that's when you see a lot of premarital agreements that say, okay, I can leave everything to my kids and you can leave everything to your kids, and I promise I won't invoke the elective share. Okay. The other solution is something called a pre-residuary trust for kids. The way those work is you would, in your will, literally, remember we talked about the residue, remainder of your estate, everything to my spouse, and then if not, my spouse is not alive, then to my children. That's a residuary trust. Literally physically located above that in your will would be a paragraph that would say something like, if I leave any assets to this Article 4th of my last will and testament, I leave it for the benefit of my children from my previous relationship in trust until they're 21 years old. So that's literally a pre-residuary trust. And what you would do with the beneficiary designations is, instead of everything to my spouse and then trust for my kids, you would carve out a chunk of, let's just use life insurance, for example, because it's easy. Out of my $400,000 life insurance policy, I could carve out $200,000 and make the pre-residuary trust under Article 4th of my will my beneficiary. So that way, at my death, my children from my prior get money in trust right away. I don't have to wait for my spouse to die. They would get it at my death. I've taken care of my kids at my death. And so that's how that would work. So here's the two possibilities. Your spouse survives you, but you have kids from a previous relationship. We do a pre-residuary trust. Again, that takes effect on your death and does not require the spouse to die first. For kids from your current relationship, we would do residuary trust, everything to my spouse. If my spouse doesn't survive, then to my kids who survive me. All right, well, let's talk about poor planning and minor children. Here's some issues that come up with kids that you need to be mindful of. As we talked a little bit about already, if you leave an asset to a minor child, you're going to get a guardianship out of that. Not the end of the world, but the biggest problem I see is that a child inherits at legal age. If you have a special needs child, and I'm talking about a child who is disabled to the point where they're probably going to be on Medicaid at some point in their life for assistance, you need to make some very, very special planning for that child. There's all kinds of Medicaid rules about how much money a child can have, how much assets, and also how much income. So if you have a special needs kid, you should be talking to a professional estate planner, or to some of these nonprofits that help parents of special needs kids do some estate planning and make sure that child is properly provided for. The thing I see a lot of is designating an adult caregiver as the beneficiary on your assets. And here's the bad idea part of this. So if I have a 2-year-old and I leave my sister all my life insurance money because I know my sister's going to take care of my kid with it, right? What happens if she doesn't take care of my kid with it? What happens if she turns out not to be the best person and she just kind of takes the money and runs? My kid can't do anything about that. So I've just cheated my kid out of a whole boatload of money, and there's nothing I can do about it, and there's going to be nothing my kid can do about it. Even if she's a nice person and I leave her my $400,000 life insurance policy, what happens when she dies? Whose money is it now? Her husband's? Does he care about my kid? Probably not, because now he's got 3 kids of his own he's raising alone. So you've set my kid up for failure by doing that. So that's why we suggested the trust for children, trust for minors, rather than designated caregiver. Now, I could name my sister as the trustee for that trust, and she could manage that trust for my children, but it wouldn't be her money to spend as she sees fit, okay? And that's why we want you to think long and hard about setting this up correctly and talk to an attorney about setting this up correctly so your children are protected at your death. Let's take a look at some of the little bit testamentary trust, a little bit more detail. Again, these are testamentary trusts, which means they're established in your last will and testament, your will. They will be effective at your death or for your kids. You get to control how and when the money gets distributed as part of the terms of the trust itself, and these are typically just little paragraphs in your will. You can say, I want them to be distributed when my youngest turns 21. They can get the principal. I want separate trusts for different children because they're in different ages. You can pick a whole lot of different varieties on how it's distributed amongst your kids. And typically what happens is if you die and the trust is created, your trustee then can spend the money in the trust for your children's health, education, maintenance, and welfare. That's pretty much anything you'd spend it on if you were alive. So a child support like stipend to the caregiver, uncovered medical expenses, band camp, school year abroad, college books, tuition, all the kinds of things you'd ever spend money on a kid is what your trustee would spend. And it's very flexible. You don't have to report to the court every time you write a check. The trustee typically does have to account to the court usually on an annual basis of what's been spent. And as long as it's for the benefit of the child, they're never going to question it. So it's very, very flexible and really is designed so that your kids are well cared for. Let's talk about how you fund these again. You got to fund them. It's not good enough to just put these in your will and walk away. The money has to come from somewhere. If you leave it to your sister on your beneficiary designation, it's your sister's money. It's not the trust's money. So you may have to make sure that when you do write your will and you do talk to your lawyer, that you ask them to help you make sure that you get all the beneficiary designations you need in proper places and make sure they're all done and things like that. But it can be any assets you want. It can be current assets. It can be probate assets if you wind up having probate assets that need to pour into this trust. Easy peasy to do. You just have to make sure you do the homework and the legwork behind the trust to make sure it is properly funded. With that, David, a really common question I get from clients is, what kind of tax liability do I have? If I die, is the government going to take everything I have? They're going to take 30%? How does all that work? And so you're the kind of the tax guy. Can you explain to folks what the tax implications are and how estate taxation works?
Yeah, and thank you so much, Mary. Yes, in fact, I am the DOD's tax attorney, so that's why I'm thankful that you brought me in on that, because I want to first thank you for sharing with our listeners the various types of estate planning techniques that you discussed here, because that is so important for them to be able to take care of their family members to use these techniques. But also, part of estate planning could be a goal of avoiding the costly and time-consuming probate process. And like avoiding the costs of probate, estate planning can also be used to avoid estate taxes. Remember when we talked about your estate prior to this conversation on taxes? We talked about everything that you own. Well, that's what your estate is upon your death, and that's what would be taxed under federal income tax, or even some states that tax estate transfers, is that it's going to look at what is in the estate upon your death. And so a lot of the tax avoidance planning that would be part of estate planning would be taking things out of your estate so that it's not then taxed as part of your estate when it transfers. But the good news is that with the Tax Cuts and Jobs Act that was passed this last December in 2017, we know now that most of our service members are never going to have to worry about estate taxes applying to the transfer of their estate. That's because the tax code now excludes estates of less than $11.2 million from the estate tax. And because of this high floor for the estate tax, most of our military pendlers will never need to worry about the estate planning needed to avoid the tax burden of estate taxes, which can be quite onerous. So if you're listening to this webinar and have an estate more than $11.2 million, first, let me say congratulations. That's great and awesome. I'm so happy for you. But also, go seek advice from an experienced tax professional and estate planning attorney and make sure that you use the appropriate actions now needed to lawfully minimize your tax liability for your estate upon your death. And so note that while most states have abandoned the estate taxes at the state level or impose very high floors like the federal estate tax does, some states still do tax the estates whenever they're transferred upon death. And so you'll need to check with those laws in your state where you live and determine if your own property that you own now and then gets transferred to your beneficiaries upon your death will impose an estate tax on that transfer. And particularly, there are some states that actually tax not just the estate itself, your property that's left over upon your death, but also will tax at the level of a person inheriting the property. It's called an inheritance tax. So you'll want to know what your state imposes and what it is called, whether it's an estate tax, a tax on the estate property, or the inheritance tax the estate imposed on the receipt of that estate's property. And thus this tax is imposed on not the deceased taxpayer, but on the beneficiaries. So you need to make sure your beneficiaries know what they're going to be inheriting and how it's going to affect their individual tax responsibilities. So again, the bottom line is that there are techniques for taking things out of the estate so it does not get taxed, but you still get the use of that property. But for most of our service members, they're never going to have to worry about that, because the amount that would have to be in order for them to be taxed on that estate transfer would be $11.2 million. And if you have that much money, please go take care of this with an experienced tax attorney and also experienced estate planning attorney. All right, so Mary, I know we've talked a lot about the techniques of transferring property as part of an estate, but it's also equally important to discuss the people you pick to take care of your property, your family, and even of yourself if you're otherwise unable to take care of yourself due to absence like a deployment or incapacitation because you're sick, or even if you're dead. And so I'd like to be able to discuss that because it is so important. You talked about fiduciaries previously, but I want to get into the nitty-gritty of it now. So the fiduciaries that you pick to take care of your estate or to take care of your person or your family are generally known as fiduciaries, and you talked about those Fidos earlier. But those are your executors, your personal representatives, the people you pick to administer your estate upon your death, such as ensuring your property is transferred in accordance with your estate plan, and that the state and federal laws for the estate plan are followed. They even may have the responsibility to make certain tax elections, which we're not going to get into now, but that's important that they understand what they're doing because it can have real effects on the tax liabilities for the estate. And likewise, trustees are responsible for administering the assets of the trust and filling out the required documents such as IRS Form 1041, which is the estate tax return that the estate has to file. And finally, your fiduciary may be responsible for the care and maintenance of your children. As Mary, you talked about so eloquently earlier, it's very important that you pick the right persons to do this because all these responsibilities are incredibly important. It's crucial that you pick the right executors, personal representatives, and trustees based upon the availability, trust, and capacities of these individuals. Choose these persons that you know are willing and able to take care of these very significant tasks because, as Mary, as you talked about earlier, it can be an onerous task that can take a while, and it is so important that you pick the right people to be able to take care of those matters for you because you're not going to be around. Likewise, with powers of attorney, it's important that you pick the right people to be your agents whenever you're not around to take care of things. And for military families, the most common way of appointing a fiduciary is through this power of attorney. A power of attorney is a legal document that assigns a person that you designate to take care of your affairs without court supervision. This is helpful for whenever service members are away from home, like on deployments, and their dependents and parents need to be able to take care of matters while they are away. A POA, the common name for it, will allow them to act on behalf of the service member within the power granted within that power of attorney or POA. Now, there are many types of POAs based upon the needs of the person granted authority to their agent. There's a general power of attorney. What this general power of attorney is allow the person to do everything that you could have done for yourself. Think about that. Everything that you could have done for yourself if you were present, this person who now has a general power of attorney is going to be able to do for you. That is everything such as selling assets, taking out lines of credit, establishing new accounts, new loans, everything that you could do yourself, they can do as well. And so with great power comes great responsibility, as I once learned from a great superhero one time. And so you need to make sure that you pick those persons that you're going to give a general power to very, very carefully. There's also other powers of attorney called special powers of attorney. And these are limited in that they are a good idea for taking care of discrete issues, but does not give ultimate authority for that agent that you pick to be able to do everything in your name. It's only those specific things that are named in the power of attorney that they're able to do. And then also there's springing powers of attorney that come in effect after an event has occurred, such as a physical or mental incapacity of the person granting the power of attorney. These are great so that those powers that you're granting to your agent don't actually get used until they're needed. And then finally, there's the concept of a durable power of attorney, which means that the power of attorney stays in effect even after the person granting it is incapacitated, so that your agents that are acting on your behalf after the power of attorney has been granted still will be able to take care of those actions even if you're not able to revoke that power of attorney because you're incapacitated. Now, finally, with powers of attorney, you can establish an end date of when these powers of attorney will end. And that can be whatever the person granting the power of attorney thinks is best. Typically, we advise our clients to limit it to no more than 1 or 2 years. There's 2 reasons for that. One is to limit the abuse. If you have this power of attorney go indefinitely, things may change over time, and you may not have thought about revoking it, or others may not know that you've revoked it, and then it is subject to abuse. But more practically, the second issue is what really comes up, is that businesses, government agencies, and financial institutions are not likely to accept a stale power of attorney. Many are hesitant to accept the old or stale power of attorney because they fear that it is being abused, that it's not in accordance with the wishes of those who granted the power of attorney. So it's important that if you have a power of attorney, we really recommend that you establish an end date for that, and that it not be for more than just a year or 2. And then that way you can refresh your power of attorney and ensure that it's more acceptable to others. And so let's talk about the agency powers that you give to these individuals. Please remember that the agency you appoint can pretty much do anything that you could do for yourself, which is anything. They can do everything we talked about. So you need to make sure that you take care of the people that you pick for these powers, and that you let them understand that they have these powers to do it, but also talk with your attorney in establishing these powers so they're limited, so that you can't be taken advantage of. And hopefully your agents are doing these actions in accordance with your wishes and not taking advantage of you because you've done your due diligence. And that's why you should seek the assistance of your institution legal assistance office and talk with your attorney before you provide someone a power of attorney to do something on your behalf. Now, there are some limitations to what your agents appointed in a power of attorney can do on your behalf. They cannot change beneficiaries on life insurance or employer forms, and there's an obvious reason for that. We don't want people who are taking the general power of attorney in and changing your designations in order for them to be the person who would receive that property upon your death. Also, they cannot make healthcare decisions for you. Now, Mary, I know that doesn't mean that you can't have someone make medical decisions for you if you're incapacitated, does it?
No, in fact, proper incapacity planning is really essential to any estate plan. It's something you really need to think carefully about. Your end of life and your healthcare decisions are incredibly important, and these are things you should spend a great deal of time thinking about. And again, it's not good enough to just sort of think about them and make a mental decision of what that is. You really need to sit down and communicate what your decisions are about your end of life and your healthcare decision making with family members. They need to know. So saying it out loud is great, but also having it in writing is equally important. There's something called an advanced medical directive, sometimes called a living will. These are usually just a little 2-pager that is a declaration of what you want to have happen to you if you are terminally ill. And when we say terminally ill, most states define that as imminent death. So you're going to be dying in a couple of days, not a couple of years. This is imminent death planning. And it's not a will, but it's a directive to your physicians about what you want to have happen to you at the end of your life. Are we going to withhold life support? The unplug me version. Do you want to be resuscitated? Do you want to be fed or watered or have that withheld? Do you want to be an organ donor? Do you want palliative, also known as pain-killing medications? These usually complement a durable power of attorney for healthcare. They're kind of like belt and suspenders, and state law governs their enforceability. The one you see most commonly about this is the healthcare power of attorney. Again, have many different names, sometimes called an advanced medical directive, but they basically function the same way. And they're going to empower your agent, whoever that person may be, to make healthcare decisions for you in the event you can't do it yourself. A lot of times now people go in for surgery and they're put in medical comas for 3 or 4 weeks. They're going to wake up, but they're just not around for a few weeks. Someone has to make a decision for you while you're not awake. This document will pick that person and will detail what kinds of decisions they can make for you. They're governed by state law. They fortunately avoid the necessity of court proceedings, because if you don't have one of these documents and your family starts to fight about who gets to make these decisions, everybody's going to court, and that is not the expense or the drama that you need in your world. They are routinely followed by medical professionals. They're rarely challenged. There's usually no reason to. They are springing and durable typically, and when we say springing, again, as David said, these will spring into action on an event. Your incapacity. So on your incapacity, this document is effective. They are durable in that they survive your incapacity. So if you become incapacitated, this document does not expire. It keeps on going. If you don't have any documents, what happens? Well, states have most states anyway, have a statutory framework of who gets to make decisions if there is no writing, okay? So this is Virginia. Again, just an example. Every state's a little different. But in Virginia, if there's no written document, then you're going to look first to see if there's a legally appointed guardian of the patient. If there's a spouse, except if a divorce has been filed, your spouse can't pull the plug on you. Adult child of the patient, parent of the patient, adult brothers and sisters, any other relatives in descending orders of blood relationships. Okay. If in Virginia, if people disagree, the folks on, I think it's 3 through 5 or 3 through 6, the hospital is going to ask for a majority vote on who gets to decide and how it gets decided. You can see how that would devolve into a pretty big mess in a hospital if 5 or 6 relatives have to get together and vote on your care. That is not what you want. That is why it is absolutely critical for you to make sure that you have these documents in place. And please, 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 as with any of your fiduciaries, please talk to them. Okay. The agent for disposition of remains. The agent for disposition of remains is a statutory document. If you're a service member, you have a DD 93 that says who gets your remains upon your death, who the government will deliver them to. But for civilians, many states now have statutes that let you make a decision on who gets your remains in writing. So it may not be your spouse. You may not have a spouse. Maybe you just have a significant other. Maybe you have a best friend that knows what you want instead of your family. So, again, these are things you should think about. Who would you want to take care of you after your death? Who would you want to make your funeral arrangements? And think long and hard about who that would be, and discuss that with them, and make sure that you get what you want and that you've appointed someone to do that. Okay, let's look at something what I call a grab-and-go book. I learned this lesson the hard way. My 85-year-old mother, David, came to live with me, and I thought, this will be a piece of cake, right? This will be no problem at all. Well, it was a huge problem. She about 2 weeks into living with me, really took a kind of a bad fall and had a very serious cut in her forehead, and she was bleeding pretty bad. So I called 911, and they showed up, and the guy says, what kind of medication is your mother on? And there was a long, silent pause. And my only response was, a lot. And that wasn't the right answer. She was on about 15 different kinds of medications that I knew nothing about. I didn't know what her allergies were. I couldn't find her ID cards because those were at the bottom of an old lady purse, and it took me a while to dig them out. It was kind of a disaster in a moment of stress, having to find all the things that my mother, the information that they needed for my mother. And so fortunately, the local county I lived in had a caregiver one-on-one webinar, and they suggested something called a grab-and-go book, which I went home and dutifully made up. And here's a little recipe for it. Go out in the local dime store and buy yourself a small notebook. And these are great for adults. These are great for kids. You know, when grandma comes and takes care of your kid, she doesn't know all this stuff about your kid. Your kid gets sick, and she's got to take him to the doc in the box. It would be nice if all she had to do was literally grab this off a shelf and go. And so this is what I made up for my mother, and then I made it up for myself and my spouse, is a little book on the shelf with all these things that you see listed in front of you. And so the next time my mother needed a 911 visit, I just handed a notebook to the man coming through the door, and he had everything he needed to take care of my mother, all of her information. And then when you go to the hospital, you've got this little book also that registration loves, and you can just hand this to them, and they have everything they need to know about you or your kid or your parent. So just a suggestion, good business, takes about an hour to put one of these together. Believe me, it pays dividends. Let's talk about document care and storage. Once you have all these documents ginned up and you have them in your hand, what do you do with them all? Well, you should store them someplace safe. That can be a home fire safe. Some people prefer bank vaults. My preference is really a home fire safe. They're sort of cheap and easy and readily accessible. But others should know where that is. If you bury this in the backyard, no one's going to find it when they need them. So someone needs to know where they are. Please don't write on them or mutilate them. People come in my office all the time with their original will. They've decided to make changes and they've written all over the original. That has just voided that instrument. Years ago, my old law partner had a little old lady who said, as you can see, I've cut my nieces and nephews out of my will, and she'd snipped out their names with a pair of scissors. So that is not effective. That is a void will. Please don't do that. If you need your will or any of your documents changed, don't write out on them. Go back to your lawyer and have them properly changed. You can make copies of your documents, but typically, unless there's some really unusual circumstance going on, you need the original will to probate. Have an estate grab-and-go book. Again, a little notebook on the shelf. Put a copy of all these things in there. At least a rudimentary list of your financial dealings, who you bank with. We don't get things in the mail anymore. We get things on a computer. So it's very difficult for people to find out where their relatives banked. Is it USAA? Is it Bank of America? No one knows anymore because these statements don't come in the mail. So at least help your family out with a list of financial institutions you deal with, including your insurance, for example. Think of it in terms of if I died tomorrow, who would need a death certificate from me? Which financial institutions? And just make a list. Put it in your grab-and-go book. Let your relatives know where it is. You will save an inordinate amount of time if they have that. So I think that wraps it up for me, David. I'm going to turn it back over to you and let you do some final thoughts for our group.
Thank you, Mary. And those grab-and-go books and the estate plan grab-and-go books, I know that for me has been so beneficial to my children and for my wife and me. So I highly recommend that, and I want to second that because those are so important in times of crises. Because we know that most people, on an average, everyday basis, are not going to have to worry about those crises. But when they do occur, it is so good to just have things ready and accessible and prepared for you to take with you so that you can take care of yourself. And
the other nice thing you can do about that is you can scan those actually and put them on your phone.
Yeah, that's smart.
And so when I used to get the phone call, Mom is in the emergency room across the county, I didn't have to go home to get her stuff. I had it on my phone. So that works great too.
It's even better.
And if you're traveling, it's handy. Mm-hmm.
So as we've gone through this class, I hope that those who have been joining us here today have been thinking about your own estate planning goals and how the estate planning process can help you ensure that your property, family, and self are taken care of upon your death or incapacitation. And most importantly, I want you to recognize that the estate planning process is a continuous process of assessing your personal needs and estate goals as you encounter major milestones in your life, such as when your family situation changes or you acquire major property like a house. And we highly recommend that you discuss your estate planning needs and desires with subject matter experts that can help guide you through to success, such as certified financial counselors or legal assistance attorneys provided by your installation or command. And success for the estate planning process is gaining the peace of mind that comes from knowing that the most important things and people in your life are taken care of if you aren't here to take care of them personally, whether that is due to a deployment or death. But not only is this peace of mind great for your individual readiness, which we're very happy that it is, it's also contributing to the increased combat effectiveness of your unit. And that's why Mary and I are here providing this webinar for you. Is we want you to be able to focus on the mission and not have to worry about if you've taken the steps necessary to provide for your affairs. Remember, the general purpose of estate planning is taking care of your family, your property, and yourself. And that is why each military department has a free legal assistance program for their service members, retired members, and their families available to them to help them with their estate planning needs. And on this slide, you'll see that there are links, and I encourage you to please visit those various websites so you can find your closest legal assistance office near you and start your estate planning process today. So on behalf of Mary, the Department of Office of Legal Policy, and the Department of Defense Office of Financial Readiness, thank you for attending our webinar on estate planning for the service member, and I wish you all well and continued success. Thank you.